very good to have you with us. We've been in touch for a very long time. We realized just an hour ago that we never met in person somehow. So yeah, very happy that you could finally make it here. You're going to talk about a subject that is of very high interest to all of us. So very excited about that. I didn't get to see the presentation, so it's also a real surprise for me. You finished your PhD, when was that now? 2 years ago?
Yeah, 2 years ago now.
3 years ago now?
Two,
okay, yeah. I'm not losing track of time yet. At the EUI, and you are finishing your postdoc in Luxembourg. I let you the pleasure to make any announcements you want to make on what's coming next. You are also probably the legal specialist of a very specific species, and everybody's wondering what I'm going to say, and it's the author. And if you're not aware of that, you have a newsletter that is called Law of
AI, Law, and other stuff.
And so every new contribution to it will finish with a little picture of an author, which is really cool. Anyway, the floor is yours. We'll do, as always, half an hour for presentation, and then we have half an hour for discussion. So thank you all for coming.
Thank you all for joining. Thank you to both for this kind introduction. It is really a pleasure to finally come here and get to engage with you and talk, also meet you in person, given all these exchanges that we have had over time. And today I have the pleasure to speak with you about what I've been working. It was the focus of my PhD. Curiously, it emerged at a relatively later stage, and I will explain that in a second, but it ended up being it wasn't what I started doing a PhD with, but it finished being what I was doing the PhD at the for the entire time. And afterwards, I ended up taking some time to polish, because in my PhD I was focusing on technology neutral regulation on artificial intelligence specifically, and now the work I will present to you is a bit broader than that, in which I propose a theoretical framework that can help us make sense of the concept, an analytical framework that helps us engage with how technology neutral regulation takes place throughout the cycle, the policy process of regulation, and some studies of how it takes place in EU digital regulation more broadly, not just artificial intelligence now. In short, what I say, and some of you might have seen that this presentation was originally scheduled for sometime in April. We had to kind of reschedule because this lovely creature, my dog Winnie, had just passed away. So, but now I have she was a lovely companion, but so I wanted to share her picture with you. But other than that, I would say that this postponement has thankfully allowed me to come to you with not an advanced manuscript as I had then, but with the first version of the manuscript. So I would say that you are the first audience to which I can talk, having a completed book, and I look forward to the discussions that will ensue of that. Because in this book, what I argue in short is that there is this thing we call technology neutral regulation that we hear a lot about. Sometimes we don't hear, okay, so what is it good for? Sometimes we have a clear answer that, okay, so this is why we're pursuing technology neutral regulation. We are looking at it because we want innovation, or we are looking at it because we don't want some actors to circumvent the law with new technology, but those explanations are not always aligned with one another. And so when we try to make sense of, okay, what does technology neutral regulation mean in practice, it can be problematic within a domain, or even if we're comparing policy in different domains. Let's say in data protection, where recital 15 of the GDPR talks about technology neutral regulation as a principle, and sees it as a way of making sure that people are still subject to data protection law regardless of the technology they use to process personal data, versus the use of this concept in the European Electronic Communications Code, where it said that technology neutrality is meant to be a way of non-discrimination between market actors, so that you don't pick winners and losers in the market. So what we have there, and when I was working on the PhD, and this is why I said that I did not start studying technology neutrality, I was working on various things related to AI. I always kept coming across this term technology neutrality, and it always seemed to me different things. So I was wondering, is that simply the case, as it often happens, that we have a term that is used for various different functions in different fields and we have to live with that? Or do we have a shared meaning that we can make sense? And I propose here in this book that this shared meaning is something that we can find, that regardless of how you're framing technology neutral regulation, what kinds of objectives you're pursuing through it, technology neutral regulation always has to do with the delegation. That is, a policymaker that pursues technology neutrality by making questions about technology, about how general laws apply to specific technological contexts. They make the technical question somebody else's problem. Who's that somebody? That can vary. It can be the European Commission, it can be regulated actors themselves, it can be a lot of private intermediaries. But all of these mentions of technology neutrality that appear to be quite different from one another end up being a variation of this formula of delegation. And this part in itself is not in itself novel, because some people have already made the connection for some time in the literature. What I see as the main contribution of this book is not just in stating this relationship between technology neutrality, neutral regulation and delegation, but rather in making it into an operational framework that is telling us that, okay, this is delegation, so what? I propose that we can, by looking at regulation of technologies through delegation, that is by seeing who delegates power to who, under which circumstances, for which purposes, and so on, we can understand aspects of technology regulation that are not particularly covered in other topics, in other forms of study. For example, we can see parallels between discussions that are taking place in the space of AI regulation, where you're concerned about how transparency is defined. You see parallels between that and discussions that are now coming to vogue in domains such as digital sovereignty and how do we pursue that at the European Union level. And that book, the book that I'm working on, should hopefully be published at some point in the first half of next year, because now it has to undergo some internal editorial processes. But there, and in this talk, I basically cover three aspects. First, I developed this, does it mean to look at the regulation of technologies from this perspective of who gets the power, how we delegate those powers. Then I discuss the policy process, that is the stages, the moments in time that take place between the initial design of a policy and its end of operations. And then I provide some case studies where I flesh out what this means by making reference to my usual domain of work, that is by regulation through European Union digital law, where we'll talk more about that later. Okay, so that's enough winning for now. And why does technology neutrality appear to be such a familiar topic? Just a quick question. Has any of you come across this term on your work, in your studies? Please raise your hand.
Which term?
Technology neutrality. Okay, quite a bit of you. And this is not a surprise because it is a term that is thrown around with a certain frequency. It is used, if you go into the initial proposal of the AI Act, for instance, they have this discussion about, we have this definition of artificial intelligence systems that is meant to be technology neutral. And then if you go to see the definition they had used at first, they said that an AI system is a computer system that is based on the following techniques: machine learning, or logic-based systems, or certain other statistical techniques. So in which sense is this technology neutral? Because from a certain point of view, it's not necessarily so, because you're talking about specific technology. You're talking about how machine learning, you use machine learning, you're using logic-based inference systems, might make the system qualitatively different from what you do with an Excel spreadsheet that you put some macros to automate decisions based on data that you extract from a database. The idea behind this definition would be that if you use these techniques, the system is different somehow, even if it does the same function than this spreadsheet that I mentioned. But in another sense, it is neutral from a certain point of view. That is the point of view that it does not mention specific technology. So you're not saying specific algorithms or specific providers. You're not saying a machine learning system, something that uses Microsoft's Azure platform, or a machine learning system, something that is built on a certain deep learning algorithm or that relies on a foundation model. So there is always this tension about how abstract should we be when we're talking about technologies. And this has been a problem in European Union law, where abstraction has been a guiding timeline since the 80s at least, where this new approach for product safety has defined that for most products, the role of the European lawmakers to define essential requirements for regulation and leave the technicalities to the market to be determined, or at most to a harmonized standard produced under request by the Commission. And that has been somewhat established as operational practice to the better regulation package of the European Commission, which, if you go there, you see technology neutral regulation and future proofing as documents that have been mentioned in the 2015 version of the Better Regulation Toolbox, which is a more detailed document that is meant as a set of best practices for the European Commission whenever they're designing a regulation or another policy document. And from that point on, you have various versions of that document, and they have kept mostly the same language about what does it mean for regulation to be technology neutral, which does not really has a definition, but associates it with the idea that regulation is somehow future-proof. That is, that it should be able to cope with technological changes. This regulation that applies should still make sense even if we change technology, which is not always the case, because if you go back, for instance, there is this paper by Michael Bernhardt in 2012 in which he looked at the data protection directive, the ancestor of the GDPR, the immediate antecessor of the GDPR, and pointed out that it had certain assumptions, even though it does not mention particular forms of processing personal data. Bernhardt pointed out that there are certain assumptions about how data is communicated, the fact that it relied on mostly isolated data, consider that data come from mostly isolated sources rather than the connection between databases we see with the internet and so on. And he made the point, based on that technology neutrality would be something impossible because you're always assuming something about technologies. And this is a fair critique, but nonetheless, people keep using this term technology neutral regulation. So we have two options faced with this. Either we say, okay, you're all being wrong, and this is a valid approach depending on the kind of critique you're doing, or what I try to do here is to offer a way to make sense. How can we make sense of this term? Can we find a way to construct that term that is actually coherent with what's being done in policy? And I'm not, of course, the first one to try to do that. There is a long lineage of people trying to conceptualize what is meant by technology neutral regulation. The foundational work here comes from Beth Jacobs, who has done this book chapter about various meanings of technology neutral regulation as a property of the legislative procedure. And like him, various other scholars in the 2000s trying to pin down what is meant by technology neutrality, and they came to definitions that they had this core idea that technology neutrality means that you're somehow indifferent about the technological specifics of what you're regulating. But the agreement kind of stopped there. We still had various different definitions. And then in 2010s, you had another wave of scholarship on technology neutrality, where people like this Bernhardt paper that I cited, or Paul Ohm and Brad Greenberg in the United States have come back not with the idea of making sense of the concept, but pointing the limitations of it as an ideal for regulation. Pointing that, okay, there are some cases where technology neutrality might not be the best thing, that might not be sufficient for might not lead to our outcomes, or might even produce some side effects. And here it's particularly illustrative to look at what the critique of Paul Ohm, where he had pointed out that when you're looking at surveillance law in the United States, there was a time where every kind of surveillance tool that the law enforcement agencies wanted to use had to be subject to a particular framework. So if you want to wiretap, there was a particular framework for phone wiretaps. If you wanted to record people with a physical wire, there was a different legal framework. And then at some point in the early 2000s, that was unified with a technology neutral framework that would not make distinction between technologies. And Ohm argues that in this process of trying to find common trends between security instruments and focusing on what they are talking about, that is about the when it's acceptable to monitor somebody because of law enforcement reasons and so on, we lost some control over law enforcement action. And these are the general lines of critiques of technology neutrality, that if we move too far away from technology, we are giving up on things that are important from a legal perspective. And then if people have tried to pin down the concept, tried to pin down its limits, what's left to say? The point is that if you look at the literature that discuss technology neutral regulation in the 2020s, nowadays, people know about these works in the past, but the discussions end up being a bit of the same. We're still trying to pin down, okay, so what does this indifference mean in practice? We're still pointing out, when might technology neutral regulation be a bad idea? And there was this scoping review by these two Finnish authors whose name I will not mangle at the moment, but where they point out that one of the main problems that people who are subject to digital regulation, that is developers, even authorities trying to implement regulation, right, is that the concept can be construed in various ways, so it gives you a certain flexibility. And so, given that the questions I was interested in ended up bringing me back to technology neutral regulation, I thought that maybe I can try and find out one way to make sense of this discourse. And given that this debate has been going on for a long time, I find it useful to approach with certain humbleness, but still I want to add something to the table here. First contribution I would make is that we sometimes, when we're talking about technology neutral regulation, we can end up mixing it with two related concepts. The first one is one of value neutrality, the idea that technologies are just tools that we can use for good and for bad. This is an argument that has a long story about do artifacts embed values or so on, and this is an important discussion, but it's not the discussion about technology neutral regulation, because you might have a situation where, okay, you agree that artifacts embed certain political values of those who are making them. For example, Langdon Winner would say that nuclear reactors, when you have a nuclear reactor, because you have to keep the residuum safe, because you have to secure materials that are radioactive, that necessarily pushes you towards a more authoritarian social structure, towards a more centralized government approach. And you might find that, okay, certain technologies have certain values, but you still might decide that the way to regulate those technologies is not necessarily by focusing on technological details, by caring about the difference. You might look instead at what people call socio-technical change, that is the effects of technology in society and how they are produced not just by the properties of the technologies themselves, but also by the way people use them, the way people control their access to technology and so on. So when we're talking about value neutrality, we're talking about the content of regulation, whereas technology neutral regulation is something about the shape of regulation. Likewise, when we're talking about net neutrality, it is a different discussion that can be somewhat connected, but when we're talking about tech neutrality, we're talking about whether providers can distinguish content, can offer separate, differentiated treatment to content depending on whether Netflix is demanding lots of bandwidth, so we could charge it differently because it has different needs from a basic internet user, or so on, whether you can charge things differently. And once again, this is a discussion about content and how it's legally treated. And whereas this debate about technology neutral regulation is a debate about the process and the shape of regulation. And this debate ends up mattering because technology neutral regulation is not something that is a quirk of the AI Act. It's not something that appears very limitedly. If you go to the various policies, recent policies in the European Union, like the proposal for a new cybersecurity act, you see claims that regulation should be technology neutral in tackling the new risks regarding the supply chain of governance. If you go into the international law, you have pieces of international trade law, such as the Agreement on Technical Barriers to Trade, that says that national governments should have limits on how they set up technical standards and other things. They cannot use that as a way to interfere with international trade. And then you have all these examples that I mentioned, the GDPR, the internal regulation of communications. So everybody's using technology neutral regulation as a way to achieve certain goals, but it's not a panacea. You cannot expect the same regulatory instrument. Every regulatory instrument, regardless of how good or badly drawn, can help you achieve certain things, and it will not be so useful for others, because point of regulation is precisely to shape human behavior, to shape how people act. And so, if you have something that pursues those goals that are not always going hand in hand one another, this concept ends up becoming a magic concept. So it's a nice word, technology neutral, it seems neutral, neutrality seems good, seems in line with our values. So legislators with different ideological commitments can agree, let's vote on this regulation should be tech neutral. And then leave the problem for other people. And this is why it makes sense to look at technology neutral regulation as a form of delegation of powers, because if regulation at some point needs to be applied to specific technologies, to specific technological contexts, and the legislator or the rule maker, if you're dealing with administrative norms or so on, that actor does not provide you with detail about how those whether and how those technological details should matter, somebody else will need to fill in that gap. It might be an administrative authority when they're implementing the law, trying to enforce the law against a perceived violation. It might be, let's say, a corporation trying to develop their new AI system and making sense of regulation. So why do we need to look at this from a different theory? Why can't we fit this into different aspects? I propose that there is a value in looking at focusing delegation, because there is this acknowledgement that delegation is somehow relevant for technology neutral regulation, but it's usually presented as a consequence. So technology neutral regulation is often defined as a property of the text where you don't mention specific technologies, and then because of that there is delegation. And my proposal is that if we focus delegation here, we look at how that delegation of powers take place, then that will help us not just understand what these different people talking about technology neutrality are talking about. That will also help us find out problems to explore when we're talking about regulation. And what kind of problem that might be. So, in summarizing things that I developed in more detail in the book, we find that if you look at this, a technology neutral regulation as a form of delegation, that a lawmaker is either explicitly tasking somebody else with the task of finding up norms, as is the case, for example, when the EU lawmaker says, oh, the Commission must adopt an implementing act saying that what criteria we will use to evaluate whether an AI model counts as a general purpose AI model with systemic risk. That's the case where you have a norm where the delegator says, this is not my problem, this is your problem now. But sometimes there's no explicit delegation of powers. For example, one thing that is very common in digital regulation is regulation by design. That is a provision where the law commands the actors that are providing a given technology, let's say you're talking about the GDPR, commands the data controllers to adopt technical and organizational measures in the design of AI systems that will implement the legal requirements of the GDPR. So this does not mean you have the power to set up norms, but in order to fulfill these requirements, the provider who's obliged, the data controller who's obliged to meet this requirement must first understand what the requirements are applied, then interpret those to understand what they require in that particular context of data processing, and then determine, oh, given my understanding of the law, how do I implement that into code? And this kind of decision can can persist for a while, because depending on the kind of system, if you're developing an app that might be discarded quickly, that won't last, but sometimes technical decisions made in software end up lasting for decades. If you go to any public service organization, or if you go to more established private actors such as banks, you will see that they often rely on, for the operation, systems that have been developed decades ago. So something that a programmer made in response to software requirements in the 1980s might end up constraining whether and how we can comply with the law in the 2020s. And these decisions are not often, because they're sometimes taken by private actors or taken within public organizations that are operating ways that are covered by secrecy, such as tax authorities developing their own AI systems and so on. When these actors interpret the law, we are not always sure of what kinds of controls there are, because if there is a formal delegation of powers, in administrative law, you have certain conditions to exercise the powers that are delegated. You have certain limits to what can be done and certain possibilities of judicial contestation. But if you don't even know that the delegation is taking place and private actors actually determine the interpretation, who is going to sort that out? In this case, coming to add some concreteness, let's come back to the regulation by design example. If a data controller decides to interpret the law in a certain way, it's going to be overseen by a data protection authority might find that if they inspect the design practices in the context of, because they're inspecting an organization for other reasons, because there has been a complaint or something. But me as a data subject, I might have very little ground to argue that, okay, maybe those decisions that embedded a particular interpretation of the law are not necessarily the best representation. And there's also the question of whether technology neutral regulation makes difference at the end of the day, whether it produces the effects we expect, because we expect it to do so many things, to improve innovation, to make sure that the law is applicable everywhere. But there's very little literature about whether it works or not. There are people, because it's very difficult to say whether whether even if you have regulations that are technology neutral and they work, or regulations that are technology specific and do not work, as is often an example. We have various horror stories of regulation that broke down because it talked too much about technology. There is this case in South Korea where there was a mandatory use of a security protocol, security plugin based on the ActiveX technology, which was arguably the state of the art in the late 90s when this law was, early 2000s when this law was passed. But it continued in the books even after this protocol became vulnerable, after it was discontinued. And so for until 2013, when this law was repealed, you had a protocol that was supposed to make people safe, but did not make it safe, but continued being used because it was mandatory by law to use that for certain applications. So it's easy to see how technology-specific regulation can break down. But if technologies, one thing that I developed in this book, and I won't have time to expound here, is that it's not guaranteed that simply by making technology somebody else's problem, it will be enough to solve. Because sometimes you transfer powers to actors that don't have the competence or the means to implement properly the measures, or some actors might have different interests, especially this is a known problem on private co-regulation, but it's also something that we have to keep in mind when we're talking about public actors being also regulated, things which are common, for example, in the EU migration sector, where you have this agency called the EULISA that is responsible for lots of development within the EU context, lots of the systems that are used for border control and management. And those actors can themselves delegate some of those decisions, because this agency that I just mentioned, EULISA, for the most part, even though it's responsible for many of the big systems that those of you that come from outside of Europe might know about, the entry-exit system, ETIAS, and other things that affect third country nationals such as myself. Those companies are responsible for ensuring that the systems meet the requirements expected by law, but they often outsource themselves those decisions. So the fact that you have a law that makes somebody else responsible is not necessarily making sure that this second actor, like the commission or the agency, is actually the one making the decisions about technical actors. So it's important when you look at it as delegation, it helps us also see that people can delegate, keep delegating powers, and this might be important for if we're evaluating the impacts of regulation, or if we're trying to understand whether legal controls are applying. And one particular example that I will highlight is that of transparency regulations, because you might have seen in laws of such as the IAC, the GDPR, you see things like the right to an explanation, the right to obtain meaningful information about the systems. And this is something that has been present both in the legislative text and also in legal decisions, not just legal decisions about data protection, but if you go, there is substantive case law, for example, in taxation. Here in the Netherlands, you had the city case, but you also had decisions of higher courts in Slovakia and other EU countries, where we found that there is a right, people have rights to obtain information about AI systems, about other forms of automated decision making. But those forms are specified in very abstract terms. And when we look at those terms of what you must provide versus what the technologies that we have for explanation can provide, you start to see that those technologies, because they are oriented for other purposes, they cannot really fulfill this task that the legislation expects of making things transparent enough so that we can trust decisions. Because all the techniques available for making AI systems less opaque, they all presuppose that you have a certain trust on the system. They presuppose that you can trust that an expert can read the code of an interpretable system, that the documentation that you receive as a request or the source code that you receive is actually in line with the program that it's running, or that an explanation method has not been tampered with. And this gives us an example of how the use by washing their hands of these questions of the specifics of transparency in context of AI, courts and regulatory agencies can often miss the mark on finding out whether their measures that are compelling for transparency are actually providing any meaningful insight about artificial intelligence systems. And before wrapping up, I'll just mention the two other cases that I developed at the seminar. The first one is that I look at the cybersecurity framework in the European Union, which in recent years, which originally was pretty much based on technology-specific regulations. There was much attention to what kinds of technical vulnerabilities were meant to address, but in recent years we see a shift towards technology-neutral regulation in the security domain, which has allowed the European Union to claim more power in this domain. Because if you frame those things in abstract terms, and if you by framing the regulation in more abstract terms and expanding what it means by security, instead of looking at security of specific devices, you have things like in the proposal for a revised Cybersecurity Act, you have a whole new part of the regulation about the governance of supply chains, which is framed in technology neutral terms, precisely the means of finding a way to expand the space of what is regulated at the European level versus what is regulated at the national level. And the European Union has expanded this in various other ways. And we also see this movement of technology neutrality in the pursuit of digital sovereignty, because even though you have a greater attention to technologies, nowadays you have but this attention is not geared about the specifics, the technicalities of regulation, which are still pretty much delegated to standardization bodies and so on. But nonetheless, the European Union has seen, the policymakers in the EU have seen as their task of trying to control the origins of these suppliers, which companies control our cloud infrastructure, which cloud companies provide our AI technologies, and also to exercise some measure of control over who are the intermediaries, let's say. So if you have rules that are based in standards, you try to get out possible sources of external influence, as they have done with the IAC in excluding ETSI, which is a standardization body where you have more involvement of non-EU private economic actors. And so they excluded this to make sure that the standards for the IAC necessary for compliance with the IAC would be developed by local organizations. And so, to wrap up, and now fulfilling the promise of the author, the point is that looking at technology neutral regulation won't solve us the problems, won't solve the dental health issues on the world, won't solve all the problems here, but it gives us a tool through which we can see parallels between problems such as those that I discussed on the chapters, and it can also help us import tools from other disciplines, because after all, the issues of delegation have been studied by administrative lawyers, by private lawyers, for example, in corporate codes and so on. And by importing those tools, we can provide some more robustness on the kind of thing that we want to do when analyzing the shape of regulation. And we can also understand the private are acting that. So I invite you to look at the book whenever it's out. And I thank you for your time. Hope this has been a fruitful presentation for insights, and I look forward to your questions. Thank you.
Thank you so much. All right, I'll abuse my position here as a moderator with 2 short questions. I'm guessing we're going to have a lot of questions, so if I can ask for short answers, this would be amazing.
Sure.
First, if I may say, I find it incredibly clever. The way you present the research and what you do with it is very unique. So thank you so much. The first question is this. I'm actually not sure if there is, you say there is an agreement as to what is tech neutrality, and that's basically non-discrimination, right? So I look at the whole class of technology. Let me take a different example. Let's imagine I have 3 kids, 18 years old, 10 and 2 years old. If I tell to the 3 of them, you're all going to go to bed by 7 p.m., this is non-discriminatory, at least it seems, but in fact it is creating a discrimination on the 18 years old, right? And going back to regulation, the AI Act, I think by claiming neutrality is non-neutral, because regulating the same unsupervised deep learning system or expert system, I would argue, is actually not neutral. So that would be my first question. What do you make out of that?
I think that this is a